Good afternoon. This is a continuation of the Lane County Board of Commissioners meeting for September 10, 2019. First item on our agenda this afternoon is Public Works item 13A, fourth reading and continued public hearing on Ordinance 19-03. I'll now read the title. In the matter of amending Lane Code, Chapter 14, to make corrections required by the Land Use Board of Appeals, remand of Ordinance 18-02, LUBA number 2018-093, and implement House Bill 2106, amending Lane Code 14.080, appeal procedures, and Lane Code 14.100, LUBA remand procedures. Amending Lane Code Chapters 10 and 16 to update Lane Code Chapter 14 references. Amending Lane Code Chapter 14 to make other clarifications and corrections. And adopting a savings and severability clause, file number 509 PA 19-05317. And today we have Lindsay Eichner, Lane County Interim Planning Supervisor, to introduce the topic. And I do have a script in front of me, so please let me know how far down the script we've gotten.
Let's see, I think you've made it pretty far down. I'm happy to present. Have we opened the public hearing?
Okay, so I guess today's I guess I'll say that today we're having a fourth reading and continued public hearing. So these Lane Code amendments are subject to applicable criteria identified in Lane Code 12.005, 12.050, and 16.252, sub 2. As I mentioned, today's date is Tuesday, September 10, 2019. The order of proceedings for this hearing will be first to hear a report from staff, followed by public testimony, then additional comments by staff. At this time, I'll describe the public hearing, and that is testimony must be directed toward the approval criteria or criteria believed to apply to this decision. Parties are encouraged to raise issues with sufficient specificity to allow the board to fully address the issue as a part of any decision. And after the public hearing and staff report, the board may continue the public hearing to a date and time certain. Because this is a legislative process, the record is technically open until the board makes a decision. However, early submissions are encouraged to allow the board time to review the material. Following the public hearing on this matter, the board may make a decision, or the board's decision may be appealed to the Land Use Board of Appeals in accordance with ORS Chapter 197. At this time, I'll call for any disclosure of Board of Commissioner abstentions due to conflict of interest or biases. Do any commissioners have these abstentions? Seeing none, I'll ask the audience, do you see any challenges to the board's qualifications to hear this matter? If so, please raise your hand, and I'll call on you to make that. Seeing none, we will move on. At this time, I will have staff make their report, then I'll open the public hearing, unless you want me to open the public hearing first and hear the report from staff.
I don't think it matters, really, does it? Should we open the?
Doesn't matter, yeah.
It doesn't matter, okay.
It doesn't matter.
So we'll hear the report from staff, and if you could zero in on what the outcome is going to be today, which is close the public hearing, or have another public hearing, or direct staff to modify ordinance.
Afternoon, Chair, Commissioners. As stated in the title that Chair Sorensen read, we are here proposing amendments to Lane Code Chapter 14 due to a LUBA remand, policy direction, and a revised and a new effective House bill. The ordinance before you in today's packet is significantly expanded from the previous readings. This is due to the outcome of a Land Use Board of Appeals remand of the Lane Code Chapter 16 Resource Zone amendments. And historically, we've added in a savings and severability clause to all our ordinances. So we've acted in the capacity that the portions of the code that got appealed or remanded were the only portions that were not effective. Luba disagreed with our argument on that in the Chapter 16 appeal and said that when they remand an ordinance of code amendments, the entire ordinance is remanded and nothing is effective. So we took all of the unchallenged language that was originally adopted in Ordinance 1802 and added it back into this ordinance. And we did not make amendments to any of those references. Mainly they were in Chapter 10 and Chapter 16s, and they were just existing references that referenced Chapter 14 sections that got moved around, or in Chapter 10 there was this handful of sections that were deleted in the original adoption. So we just added all of that text back in, and it added a significant amount of pages to the packet. So when looking through the PDF packet, that's why it's so much longer. So let's see. We also, due to that fact, the resource zones in Chapter 16, we had proposed to make some amendments. Oh, here's a list of all of the code changes that were, all the different sections that are being amended or deleted. And previously it was a much shorter list, so I just, something to look at. So in the last packet, when Amber Bell was before you, we had made some amendments to the resource zones relating to House Bill 2106 and the timeline extensions, and we had proposed to strike out some language from the version of Chapter 16 that we thought was effective, and now it has been remanded, so it's not effective. So I made the same changes to the old version of the code, if you can follow me on this. This is the effective, lawful effective version of the Lane Code, and I took what the last packet had shown as striking out, and I made it to this code. So I'm not proposing any different changes in this aspect, but it looks different in the packet. So, and then prior to the last public hearing on July 23rd, there were two sets of comments that we wanted to address that we didn't have time to prepare a response to that same day. And they were from Landwatch Lane County and Bill Close's office. And in the agenda cover memo, I went through and I addressed the issues that were raised. And so I'm going to briefly touch on some of those. One of the issues raised by Landwatch Lane County was a concern that if we remove this sentence that's shown as being deleted, that it would not be consistent with state statute. County council and staff reviewed the rules and statutes closely and determined that actually if we left the language in, it would be inconsistent with statute, and that it's more in line if we remove it. And so that's our response to that. The second issue raised was if the county had authority to allow the planning director to appeal the hearing's official decision to the Board of Commissioners based on some case laws that they cited. And the planning planning director currently has the ability to appeal the hearing's official decision to the board. The proposed amendments would allow the planning director to request review within the 12-day appeal period. Nothing in the proposed amendments explicitly allow the planning director to appeal the local decision to LUBA. And we found that the proposed provisions comply with the ORS 197. The third issue that was raised was regarding some new language dealing with when an appellant can request for the hearings official to reconsider their decision. And there was submittal requirement that required the appellant to demonstrate that the reconsideration can be completed within the applicable time limits set in Chapter 14. And there's also the same provision that requires the hearings official to make that same determination. And we did agree that it would be challenging for the appellant to know how fast the decision maker's able to make their decision. So we recommend, this is a change, and we recommend deleting that appeal submittal requirement, that the appellant demonstrate that the appeal can be reviewed within the time frame. It still is a requirement that the hearings official has to make that determination, so that we don't go over our statutory time limits, but it's not up to the appellant. And then Mr. Close submitted comments that he does not support the proposed revisions to the appeals process for the elect to hear or not to hear proceedings, and our response to that is that it's been an open discussion with the board, and we've received direction from the board to work on these amendments and add them to the code. It is a policy decision that the board has authority to make, and we have not heard any legal arguments based in statute that are opposing this change. So on top of these two letters that we received in July, today we did receive an email from Kim O'Day, who's a part of Bill Close's office. I only had a chance to do a quick read of the email. I didn't have a chance to actually prepare any rebuttal or comments about it, but if you have any questions, I'm happy to talk through them. I would also like to point out that Ordinance 1903 does have an emergency clause. So at the point that the board feels comfortable with adopting the ordinance, it will be effective immediately, versus usually there's a 30-day delay in the adoption. On the screen, I've proposed 3 potential motion options, and staff does recommend option 1. And based on discussion and public input, I'm going to hold off on the specific date I'm going to recommend for the 5th reading. I have talked with Diana about 2 options, and depending on how discussions go today, will help guide which option that goes to. So thank you, and I'm available for any questions.
Okay, do commissioners have questions before we have the public hearing? No? Okay, so at this time, we'll have, now that we've had the staff report, we will now have public testimony. After we have public testimony, we will have additional comments by staff. I have 2 people that have signed up. First is Lori Siegel. And why don't we have 5 minutes for each one of the people who have signed up, Lori Siegel and Mike Evans. And so please come forward if you wish to provide testimony at this public hearing. And our vice chair will set the timer at 5 minutes.
Hello, Commissioners. I'm Lori Siegel from Landwash Lane County. We have some written comments from Sean Malone, and so I won't addressing Lindsay's comments about our July 23rd comments, so I won't go into that. They're here in writing. We did want to say that we appreciate staff's decision to delete the requirement that an appellant establish that there is enough statutory time left to hear a reconsideration. And we want to point out that we think that the same issue exists for planning director decisions. So the situation is that when a planning director reconsideration is requested, there's not really any criteria that establishes when the planning director will or will not reconsider. We've tried it a few times, and it's mostly been ignored, the request for reconsideration. We have been told that we haven't provided enough time for the reconsideration. We do normally appeal during the last hour on the last day. However, we did that recently. This is our normal practice, and the planning director, without any request from anybody, decided to reconsider anyways. So that seems like an inconsistency. It's just an example. But we think it would be easy to have the same policy that applies to the hearing official for reconsideration apply to the planning director, just to establish a time. If the planning director needs 2 days within that 12-day appeal period to do a reconsideration, then that could be, if you want a reconsideration, you have to appeal by the 10th day. And so that 2 days is set out there. That's a suggestion. Do you understand it? Mm-hmm. We have talked about this, I think, before with staff, but maybe not as specifically as this. Regarding the references to Chapter 14 and staff's way of dealing with the Chapter 16 remand, it's complicated, we understand that, but we do think that it's going to cause some confusion because what staff has done is, instead of, in Chapter 16, instead of citing where appropriate to, let's say, Lane Code 14.100 sub A, sub little I just made that part up. Now the reference is Lane Code 14, and that's for everywhere where there would have been a reference to Lane Code 14. It's not that there's anything wrong with it, it's just, it's going to be confusing. So we think that a holistic approach would be better so that the two are side by side, the two chapters, so that the references could be worked on together. That's just another one of our suggestions. Then on a more substantive note, and I'll finish with this, thank you for the extra time, Commissioner Sorensen. Reading directly from our comments here. With regard to the passage of House Bill 2106, that was the gut and stuff bill into a dog kennel bill that Oregonians in action took to the legislature. So it was gut and stuffed with these additional 5-year amendments for forest dwellings. Several issues are before the County Board of Commissioners regarding this issue. First, the county is not required to implement the additional 5 one-year extensions. Rather, the county, quote, from the language of the law, may approve no more than 5 additional one-year extensions of a permit, end quote, if certain criteria are satisfied. House Bill 2106, Section 3, Sub 2, is where that language is found. Not only does the county have the discretion not to implement House Bill 2106 as written, but the county can also create more restrictive provisions of state law by allowing for fewer than 5 one-year extensions. Next, on a related issue, the county proposes to apply this bill retroactively. This is our biggest concern. County proposes to allow additional one-year extensions to be issued for permits or extensions issued before, retroactively, or after June 20th, 2019, which is the date of the bill because of its emergency clause. The county will again be on tenuous legal grounds because ORS 215-110 sub 6 prohibits retroactive ordinances. We have a lot of citations to case law here. I won't bother you with those. The county could confidently move forward by not implementing the bill at section 3 sub 2 at all, or by choosing not to apply it retroactively. However, if the county does move forward with a retroactive ordinance, this does raise the possibility of another LUBA challenge. And that's it.
Thank you so much. Okay, Mr. Evans, please come forward. And after you give your name and your address, our vice chair will give you 5 minutes.
Thank you, Commissioners. My name is Mike Evans. Address is 475 Oakdale Avenue in Springfield, Oregon. I testified at the July hearing, so I'm not going to repeat myself there, but just very quickly and kind of in response to Lori's comments. The 2106 was not introduced by Oregonians in Action. It was introduced by our own Senator Lee Byer from Springfield, and he did that for the population in Lane County who happen to be affected by the loss of one-year extensions. There are a lot of folks out there speaking to the retroactivity of the ordinance. It's important that it is retroactive. There are a lot of permits out there where folks were told that they had a four-year initial approval, they'd have a 2-year additional opportunity for approval, and they'd have additional 1-year approvals. That's right in their approval period. They're expecting that. LUBA decided that the 1-year extensions were not valid, and so the senator stepped in, the legislature then, after listening to a lot of comments from the public who happened to be affected, reinstated the opportunity for 1-year extensions, but limited those to 5 years. The initial request by Lee Byer was just to reinstate the 1-year extensions. The legislature, after discussing it, decided, well, 5 years was enough for people to have an opportunity to look at their investment, plan for their investment, and take advantage of that. Keep in mind that even though there are the 5 1-year extensions, should the legislature at some time in the process say, change the regulations that allow a dwelling. In other words, they say, well, we're no longer going to allow a dwelling on any parcel less than 20 acres, for example. Then the extensions would not be allowed. It's only if the regulations that allow the dwelling in the first place on farm and forest lands remain as they are when the approval was granted. So there's no good reason not to adopt Chapter 14 and accept the reaccept the opportunity for 5 1-year extensions. Beyond that, I'm not entirely in agreement with all aspects of Chapter 14, but the staff has done a lot of work. There are a lot of policy issues that you guys have come down on and made your decisions. I don't like the idea of the board not considering or having the opportunity to consider appeals, but you've made that decision. I respect that, and I support adoption of the ordinance. Thank you. I only needed 3 minutes.
3 minutes, thank you. After the public hearing, is there anyone that's not signed up that wants to testify at the public hearing? Okay, seeing no one, we will continue the public hearing to conclude any additional comments by staff.
I think we should address the retroactive arguments on both sides. Maybe I'll let legal counsel answer that.
I think for record-keeping purposes, it's okay to decide now whether you want to continue the public hearing or close the public hearing. You can hear from staff outside of the context of the public hearing if you want us to address the issues that have been raised or questioned. But that's up to you, just so you know.
Well, just go ahead.
I'll throw out a few comments, I guess, based on what we've heard. As far as the retroactivity of the House Bill 2106, if that's right. The statute's not as clear as it could be, honestly. That was the first thing I thought of when I read the House bill was, gee, I wish somebody had run this by council before they adopted it. If the intent was to deal with the situation, as Mr. Evans testified, that came up here in Lane County, which is these folks who had been granted extensions to development permits, only to see those extensions held to be invalid by LUBA. And I think the idea of the statute, the House bill, was to fix that problem. People that were granted extensions and who have held off on development in good faith based on the validity of those extensions. And so the legislature stepped in to try to deal with that problem. It clearly deals with the problem going forward. The question is, does it fix the problem of people who now have extensions from the county that LUBA's held are not good anymore? I think it's clear to me from the legislative history of the adoption that it was intended to fix that problem, that is the retroactivity problem. Whether the statute does that clearly is hard to say. It could be more clear in my opinion, but overall, staff, our office and planning were of the opinion that the statute is clear enough, given the legislative history, that the intent is to reach back and try to fix the existing problems. In other words, that it applies retroactively. And so that's the way the code amendments were drafted to effectuate that. I guess we'll find out in the long run whether that's correct or not. Ms. Siegel's correct that this board has the authority to not apply that statute retroactively, has the authority, frankly, not to apply the statute at all. It's a permissive grant of authority to the county to try to fix that problem, but it doesn't mandate that you grant these additional extensions. What other issues do we need to apply?
Can I add to that? It will not, if adopted and effective, and the previous land use decision expired based on that previous LUBA decision, say it expired last June or last May, they say somebody had a template dwelling approval and it expired last year, and earlier this year, due to the LUBA decision, we could not grant them extension. They have to reapply. So it wouldn't retroactively approve extensions for land use applications that have expired, only if they're still active, if that makes any sense. It would be, they would have to apply under the new regulation that would be effective that date. And they would have to still, the land use application would still have to be effective as well. That's, regarding the time frame issue with the planning director reconsiderations and having that be a submittal requirement, we can look into that. We can tweak that. If we delete, we would want to look into that a little bit more, as today was the first time I'd heard about that recommendation. But if it's my understanding, if the board chooses to delete a criteria, it wouldn't require 2 more readings. Just adding additional language would require additional readings. So if the board found that they would want to make those submittal requirements for the request for reconsideration of a planning director decision and the request for reconsideration of a hearings official decision be similar, then we would be happy to make that change.
Okay, on that last point then, a notice of appeal requesting reconsideration of a hearings official decision must also demonstrate the appeal can be reviewed within the applicable time limits of Lane Code 14.0502. That's being deleted. And are you also in agreement that language pertaining to the planning director on that topic should be deleted also?
We're open to making that change if the board so directs.
Okay.
Thanks. If I could just jump in for the record, Keir Miller, Lane County Planning Director. This is the first time we've seen that language, and to be honest, listening to the testimony, I'm not really sure what it does specifically, so I'd want to look into that. I do want to make it clear that we are in a little bit of a jam with this LUBA remand, and our codes are sort of in limbo right now, and that's the purpose of the emergency clause, and it would be good if it's not a substantive issue that we could try to resolve the code update sooner rather than later. But if that's something the board wants us to look into, we'd be happy to.
Okay. Other questions, comments by commissioners?
So, Ms. Siegel made reference to written comments. They weren't provided to the board.
She just handed them to me right as her
I
testimony.
do have Kim O'Day's, and I just received now Andrew Mulkey's by email and was able to read those real quick. So it's like I'm dealing from not seeing the actual written comments. So it's really tough for me to go, yeah, I'm okay to move ahead to the next reading with the current language because I didn't actually read the argument, which, gets me back to, at least Kim O'Day's, there are a couple things that haven't been addressed. One about the effective date of decision under one specific section, 14030-1B3. On page 8 of 44 legislative format, she's concerned that the wording unless further appealed adds some kind of ambiguity to it, that the effective date of decision is not clear. Just something for you guys to look at.
Yeah, if I can jump in, Commissioner, when I read that, I think the issue that Ms. O'Day is pointing out is that unless further appealed, that language creates some ambiguity because she thinks it's intended to apply to the internal appeal process, that is to the Board of Commissioners, which of course is the current status. If change is made to do away with the elect not to hear, there would be far fewer appeals to the board, and therefore this language maybe creates some ambiguity. There is still would be the potential to appeal to the board when the planning director requests it. And so maybe simply adding language after the words unless further appealed, insert to the Board of County Commissioners might cure that ambiguity. Unless staff thinks I'm reading that wrong, if the board wants to do that, you could do it frankly today to avoid the need to push it out for another reading, simply by reading that language in. So
what was that language again? To add?
After the words unless further appealed, if you insert the following words to the Board of County Commissioners. I think that would resolve the ambiguity about what appeals are being referred to when you're talking about the effective date.
May deal with that specific issue. The next couple, I think, are much more difficult to deal with. It's interesting that we have both sides that are very concerned about the issue of the planning director having this discretion to decide when something comes to the Board of Commissioners or decide when to ask for reconsideration, and placing that power in the planning director's hands. In her second comment, she's specifically concerned about the planning director being the one that's allowed to request a Board of Commissioner hearing so that we have deference. It's suggesting that process really should be that the planning director requests the hearings official to make that request, which would be a complete change in process. But it gets back to, this whole thing gets back to my concerns about eliminating elect to hear. I lost that argument with the board, so I'm not going to relive that argument again, but I truly believe that our elimination of the elect to hear process and losing deference in the decision making when we go in front of LUBA, and I think Ms. O'Day in her third comment even cites a really important decision, a recent decision with the Country Fair, where deference was the major factor in their decision making. So that's, you know,
To jump in really quick, and have discussed this deference issue before, and so I won't prolong that discussion. I mean, Ms. O'Day's general thrust is correct, as this board knows, that deference strategically is helpful in defending county decisions. As to that specific case, I'm not convinced it's the language the board uses, and the case is the Oregon Country Fair case, LUBA case, that was just sent back, or not, it was affirmed, I'm sorry, on September 9 is when we got it. It does use language that seems to indicate that LUBA thought deference was important. In other words, it says that, that the petitioners in challenging this thing didn't point out any inconsistency with statute or local code. And that's generally the language that you see when deference is at issue. That is, it's deferring to the county's decision because the petitioners didn't show that the decision was inconsistent with a statute or a code. Without deference, that decision, well, there's not you don't defer, you don't give as much weight to the county decision without that standard. That is, if the county is not interpreting its own code. The language here doesn't indicate that it was based on deference, frankly. That I think LUBA could have upheld this on deference grounds or otherwise. It's not clear because it doesn't, there's only a paragraph of it. It doesn't sort through it all. So I don't put too much weight on this current decision, but certainly there are ones where the difference is deference. That is, did the LUBA defer or not to the county decision? So it can make a difference. I'm not sure it did here.
but does get back to the way we tried to deal with losing deference was to have this ability for the planning director to send something to the board to gain that deference. And I guess some of the questioning from both sides, you know, when you got Bill Close and Land Watch concerned about that decision factor lying in the planning director, who is not an elected official, not appointed, deciding when something does do that or doesn't, and you know, Land Watch is more concerned about when a reconsideration by a hearing official is requested. Kim O'Day is more concerned about when it comes to the board, but it's still this authority lying in the planning directors, where it's not either the applicant or an interested party making that request. You know, that's the, you know, our current system is the planning director doesn't get to really decide that stuff. It's usually, you know, usually at the request of somebody involved in the decision, and a party of record, you know?
Well, to correct, I think there is some authority currently for the planning director to recommend things go to the board, or for example, the planning director will conduct or make a decision and has the authority in certain cases to elevate that immediately to the hearings official to decide. So there is some authority that the planning director has now to recognize things like matters of county interest. And I think that's, of the parties involved, I think it's correctly placed with the planning director to consider whether this particular item is a matter of countywide significance such that the board really needs to speak to it. I don't think that's an issue that the hearings official generally should be dealing with. The hearings officials are more applying law to fact in deciding cases, whereas the planning director has the authority and responsibility to look out for the county planning system more generally and decide which of those cases are important enough for this board to consider. And that's why it's written the way it is.
So I guess you probably haven't seen it, but Mr. Mulkey's concerns are about two different terms that they're concerned about. One's the appearance, and the fact that the definition of appearance is they want somebody that submits written testimony to be considered appearing and have standing, so that, you know, that rather than having to be actual appearance. So I don't know if that's something we can straighten out now. And the other issue they have is around deadline and electronic materials over 20 pages in length, and an issue in there. But those are the two issues they're writing about at the very last minute.
Mr. Miller wanted to add something.
While Mr. Clark reviews maybe the comments from Mr. Mulkey, I'll just mention that I have read Mr. Malone's comments that were just submitted. And from what I can tell, I don't want to paraphrase him by any means, but all of the concerns mirror, as far as I can tell, the comments provided by Ms. Siegel, just in more detail. So it's the same issues raised with the generalization of references to Lane Code Chapter 14, the language regarding the appeal criteria, the appellant to explain that there's enough time in the timelines to make a decision, et cetera. So I don't see anything new in these comments from Mr. Malone.
Okay, I'll just mention that in the middle of all this, I heard Mr. Malone's name mentioned, and I just want to make it clear I didn't know he was participating in this, and I don't have any contact with him on these topics. We do have a business relationship that doesn't involve any of this or even communications about it. So I just want to get that on the record. I don't think I have any conflict that's previously been discussed here. Okay, Commissioner?
I just want to state that it's difficult for me to weigh in when we're receiving comments 20 minutes after we began this meeting. And that's just a general principle. I don't know about anyone else, but when I feel that more information comes in, I want to look at it. I'm not saying I'm the smartest eyes in the room, but I'd like to look at it. And this, even in this report, I've heard different people suggest that, well, I haven't really read this, or I've read it, but I haven't really analyzed it yet. So I just want this board to know that my opinion is we're not prepared, and I would like to be prepared.
So to give us time to read all this and set up another reading on it, what do you have in mind for that? Because we did get, I guess apparently we got a letter from Sean Malone, we got a letter from Kim O'Day, and we got a letter from Mr. Mulkey. Did we get anything else in the last few days?
Nothing until noon, 12:15 today.
Okay.
And this,
All right. So why don't we
Mr.
just,
Mulkey, I didn't even know we had
yeah,
it.
why don't we
until
give your,
Commissioner, so.
give us your recommendation based on what, all the material you have to review, and give us time to review the material.
Diana said there's room on the October 1st agenda.
Okay. All right, so that would be, looking at closing the public hearing and setting the deliberations on Tuesday, October 2? Tuesday, October 2?
October 1st.
October 1. Okay. All right. Okay. And so Commissioner Buck.
Just for clarity, I too have not read these 3 new testimonies, and if we come, I want to make sure when we come back on October 1st, we're not sitting in the same ballgame where we're sitting here talking about it, and all of a sudden, we have, more emails. Yeah, so exactly. I was interested in when we are going to put a deadline on closing the record so that we know we've got what we need and we can make a solid decision.
One dilemma which staff's already pointed out is that this is a legislative matter, which means we can close the hearing, we cannot accept more items for our record, but that doesn't prevent people from giving their points of view on it up to
Quasi-judicial.
Yeah, it's not quasi-judicial, so it's not where we're banned by the record that's in front of us. So that's the reason I was suggesting we close the hearing. We close the record, we have our deliberations set for October 1, and then all the material that's been submitted thus far, and even up to the point of whenever you can, review that, and their recommendation will be based upon the record as of now, as of closing the record now. So the short answer is, you can't stop people from giving you their perspective on legislative issues before, during, or after the hearing.
And further to that, the land use record that the planning staff will keep will include everything that comes up to and through the county decision in the matter. So
Right.
yeah, closing the record or not, you're right, doesn't accomplish much in a legislative context.
Yeah, that's why the proposed motion is move the fourth reading, close the public hearing, and set a fifth reading and deliberation on October 1 at 1:30 PM in Harris Hall.
Mr. Mokrahysky points out there's a time certain at 1:30 on that date, so maybe push it to 2 o'clock if we need a time certain. I don't think we do without a hearing, but just for Diana's purposes in scheduling things.
Yeah,
Oh, yeah, let's leave the time out.
okay.
Just put it
All right, so continued questions by commissioners, comments? Commissioner?
I was ready to make a motion if that's,
Okay, go for it.
so I'd like to move approval of the fourth reading as presented by staff with the amendment of section LC 14.0301B3 to add after the words unless further appealed to the Board of Commissioners, to clarify that. And that would be the only amendment to the reading. And have that be what we're approving as the fourth reading and setting the fifth reading and deliberations for October 1st, 2019.
Second.
Okay, and then how are you handling the extension issue? Because that came up in the testimony from Mr. Evans and Ms. Siegel.
As it's proposed in the code, we're fully implementing what the House bill allows us to.
Maximum of five
Five.
one-year extensions. Well,
Yes.
why not have a lower number, like one?
We could.
Yeah, okay.
I don't think the discussion hasn't been had on that. I think,
Do you want to have a direction on that, one way or the other? Or in your view, it's already been provided to use a maximum five?
It's clearly a matter for county policy, and so it's up to this board whether you want to implement the full range of what the statute allows or tailor it back. I don't have a very good memory of it. I thought the board had generally discussed the idea and was okay with going forward with what the statute allows, but if there is to be further discussion, now is perhaps the time for that.
Okay,
If the board chooses to do that, we'd also appreciate direction on the question of retroactivity as well that was raised, whether or not we want to include in the language the ability to apply these timeline extensions to applications that are currently in the queue or new ones that are submitted in the future, because that is, as Mr. Clark pointed out, the statute, the bill wasn't exactly clear on that, but on the legislative intent, staff and legal counsel concurred that it appeared that was the purpose was to assist these individuals who had been acting in good faith, making applications and having extensions made to apply that bill retroactively to them as well. So if the board is going to make a determination on the number of one-year extensions that are available, it would be helpful also to know your policy direction on whether or not they can be retroactive.
okay. Okay, other comments by commissioners on that? Yep.
I do have one comment, and Ms. Siegel's testimony here today, actually the first thing was interesting to me, where it sounded like the hearings official timeline and the planning director timeline weren't necessarily matching, or one has a timeline, one does not. What are your thoughts on that?
I believe that issue's been addressed because we're recommending that we delete that provision regarding the timelines for appeal. And that basically, the way it would work is, as originally proposed, we were requiring the appellant to make a determination that before they submitted an appeal, by submitting that appeal, there was enough time built into the process for the hearings official to make a determination. Well, they have no way of knowing whether or not the hearings official can make that determination in time. But there's a parallel provision that the hearings official, before he or she accepts that appeal, has to make that determination as well. So it was redundant, and honestly, it didn't make sense for the appellant to have to demonstrate that. So I believe that issue's been addressed.
Okay, thank you.
I think what Lori brought up is that there's the same issue in the planning director reconsideration. And I didn't look at that when preparing these changes. It wasn't brought up in their previous comments.
So again,
So-
that's probably another good thing for us to look at with this additional time. So.
Yeah, so, and it would be easy to strike something like that out if the board wants to direct us to do that. We made that recommendation in this packet to remove it from the hearings official reconsideration. It makes sense to remove it from the planning director reconsideration.
So will you be
I'll do
doing-
some further research into it.
Will you be doing that, or will that be just, how will we structure what will be in the packet for the October 1 decision?
From what I understand, it's the same exact issue, just it applies to the planning director process, and the logic holds in one situation, it should hold in the other, and we would strike it from that process as well.
And we don't have to have another reading on that. That'll be read at that time. Is that correct?
Yeah, you can make that deletion if that's all it is during your, might be the final reading on this on October 1st without having to go to another reading.
Okay, and then as it stands now, is there an opportunity for 5 one-year extensions?
Yes.
Okay, and if we don't take action on that today, the board could take action on that in an amendment to what is presented on October 1.
Yes, and my guess would be, without reviewing the language specifically, that we would need to do enough to the language that's there to push that out for another reading. I doubt we could tailor
Yeah.
that next
Yeah.
time to avoid it.
Because we'd have to address retroactivity
Okay.
also.
Right.
Okay, well, I'd like to see us limit the number of those extensions. I would like us to not use that full authority and just be a little more judicious about how we do that. So that's my preference. Yeah.
Yeah. As we have a motion on the table to approve the language with the 5-year, at least for the next reading, that's the way we have it. And I believe we've had this discussion previously in Chapter 14 discussions. This would probably be the third time we'd have that discussion. Every time we've come to the conclusion that we're good with the 5-year, because we're going from unlimited to a 5-year, that we're already, cutting off people's ability to continue that. And at this point in time, then anybody moving, there are some people that may have, been doing the unlimited 1 years up to this point, but we're stopping that. In 5 years, they either have to build or lose their approval. And from when we adopt this code, and any future approvals we give are only going to be eligible for these 5 one-year extensions. The original 2, I forget, 4-year approval too, and then 111 or something, I can't remember. It's still a limited time. So we're doing a significant restriction. So I'm not interested in rehashing that discussion. And it was specifically meant to try and protect those folks that have been counting on those unlimited 1-year extensions. So I think it has to apply to the folks that haven't lost their extensions at this point. That if they have a valid extension in place, that's not necessarily retroactive. It's just saying now that with this change in code, instead of unlimited extensions, you only have 5 years, 5 one-year extensions. So I think that's a fair thing to do, and I think the board came to a majority agreement at least once, if not twice before, around this issue, and rehashing it for a third time seems unproductive.
Hey, Commissioner Bernie.
I'm not going to engage in the discussion of whether or not to rehash it, but I do have questions that I honestly don't know the answer to, and they're probably dumb questions. So most of these extensions that we're talking about, are they like individuals that are building their forever dream home, or are these developers that are positioning the property to sell? I just don't know. I apologize.
It's both. It's both.
It's
I mean,
both,
all
but does it
different kinds
lean
of
one way or
people.
the other, or no?
It's hard to say. I mean, sometimes it's a developer who got the land use approval because they are familiar with those ways, and then they sell it, and then it's the new owner coming in and trying to get time extensions. Or sometimes it's a property owner who's hired a land use consultant or land use attorney to help them through the process.
Right.
And it's their forever home. It's both.
My sense is that it is both. What happens often is there will be a developer and they'll have a number of these holdings and they'll bring them to a certain point in the process and then they'll offload them to the moms and the pops who want it to be their forever home, and it's almost, they're working through the process. So most of them start off in, kind of a larger developer's, portfolio, and then they get pushed out somewhere along the process. I think in general, the majority of them that are out there seem to be owned by, if I had to guess right now, most of them are developer owned, but there are some that are owned by, just regular folks.
And trying to be prudent with county revenues. When these, before something actually gets built on them, are like they paying the same property tax rate that I am? I own a raw lot in Springfield. Nothing's on it. I can build whenever I want. When I do, I'm going to have to get the permitting and the things approved. And I'm being taxed a fair amount for that lot. Are these properties taxed at a proportional amount, or are they under a property tax deferment that would, I don't know, I'm sorry, yeah. Because that would affect my decision getting into this or not.
Yes, the property tax is not within the purview of the planning staff, but yeah, generally, the tax assessor assesses property as bare land until it's approved or improved, at which point the improvement and the real property.
I know, I'm taxed bare land for bare land I own in the city limits. Is this the same tax rate, or does county receive the same type of revenues on this property that we're discussing?
Well, if the question is, does the tax rate go up when you have a permit approval but no building, then no, I don't think so. I think it's all, is it improved or not? It's the only question for tax purposes. Is that what you mean?
There's also the issue of farm and forest deferral. If in these undeveloped lots in the county are in that tax deferral because they're being used right now primarily for farm or forestry purposes, that will lower the tax rate as well.
And some of those may continue after development or not, depending.
Right.
So.
Mr. Miller answered the question, I think, accurately, that most are developer initiated, and that's part of my concern about having this long period, this 5 years that we are allowed to use. But really, I feel like we need to clamp down on this, and if they are going to be developed, then why can't they be developed within the 1 year period of an extension? Why can't they be? If they can't, and the answer is, well, why wouldn't we? Well, the answer is they can always apply again. They can always apply again. Maybe things have changed. Maybe there's other people in the area. I don't know. But just to keep extending and extending. And then, as was pointed out, we don't get the tax revenue. We don't get the tax revenue because and that may not be subject to a land use decision where we have to be confined by the record, but as was previously mentioned, this is a legislative process and we're supposed to take in the public interest in making these decisions. So I just think we should try to get some kind of limit in there at this point so that people, when they see our deliberations on October 1, they see what we have in mind. And So do you want to make a motion, or how do you want to do that?
There is a motion on the floor right now.
No, I mean a motion to amend what's on the floor.
I'm not prepared. I thought we were going to do this in October. I was just asking questions for information.
Yeah, well, what we're going to do in October is we're going to have a hearing, we're having a deliberation on a proposal that, at least as far as the motion is concerned, is 5 one-year extensions will be the policy of Lane County. That's what we're going to be deliberating on October 1, without any amendment. Yeah.
Go ahead.
I have a comment, a couple questions. Since we're on the subject, this retroactive ordinance, how many permits, I should actually ask, does that really affect?
Previously have it. It's less than 100, I believe. It's probably significantly less than that now.
To define that, is that folks who have already had a 4-year extension, a 2-year extension, and now beyond that, 6 years? Does that make
Right.
sense?
We could find that information again. We did look at that initially when this happened, but folks have been working their way through the process. I did just ask Mr. Evans if he knew how many of his clients were in this situation. He said he thought around 12, and that's just Mr. Evans.
I guess those numbers would not include applicants who are in the first, they always get a 4-year approval period, just without any extensions. And I don't think we necessarily queried all of those active applications. So there's probably more than that. But we were looking, when we were queried information, it was people who had applied for at least one extension after.
It's not an insignificant number, and we can certainly provide the exact number.
It would be great for me to know that before October 1st, out of a curiosity, because this obviously affects a lot of people that are in the queue. And I don't know who they are, or how many of them are in that queue, whether they're developers or mom and pops. I've actually heard from mom and pops personally, but I know that there's lots of folks in that queue. I've had discussions about this issue of whether we keep it at 5 years or go to something less. And what keeps coming back in my brain is, regardless of whether it's 3 or 4 or 5, there's nothing hindering somebody coming back and just reapplying, is there?
No, there's not.
Time and cost.
Right.
Sometimes case
true.
law changes,
Certain.
and then it wouldn't be approvable.
Yeah, but there's nothing saying they go through all these extensions, which I think total 11 years, once you first apply. And if you went through the process, you get your 4 years, you get your 2 years, you get your 1-year extension, so you get a total of 11 years. I mean, if you're not going to build on the land in a decade, I don't really know what you're doing. But I'm sure there's other plans that I'm not aware of. It just seems like even if you limit it, and it's a circular question I've been going through, is say we limit it to 3 years, for example. They can reapply. There's nothing stopping people from reapplying other than you have to pay the fee again and start the process over. So for me, I have not come to a solid reason why it should be changed from 5 years right now, unless there's something I'm not aware of.
Okay, Commissioner Farr?
Thank you, Mr. Chair. I'm anxious to get to the vote on this. Just one thing I want to point out is whether it's a developer or whether it's mom and pop, ultimately it's mom and pop that are going to live in the residence. I mean, this is not going to be lived in by a developer. It's going to be lived in a residence. And I hope we're not just stating out loud that we want more places for people to live in Lane County. Now, we have to abide by the rules, we have to abide by the laws and all the lengthy timeframes that exist and all the fee costs that exist. But that being said, facilitating people building homes is something that we should be attuned to. And really, whether it's a developer or whether it's me planning a future development on property that I own, it really ultimately, it is a home for people to live in. And I'm not wrong with that, am I? I mean, we're talking about homes for people to live in. Are we talking about homes that people will ultimately live in? Question? Yes, we are. Okay.
Okay, Joe?
Forgive me, the unending conversation. Something Commissioner Buck said, so we have 4 years plus 2 years already, correct?
Right, once you have a
6
land
years.
use approval, you have 4 years to build something according to that land use approval, and you can also correct and then apply for a 2-year extension.
I'm going to continue even though I hear someone say, yeah.
There are certain dwelling approvals that they have 4 years to meet all of their conditions of approval and apply for their building permit and start building.
Thank you.
And then they can apply for a 2-year extension, and that's laid out clearly in statute.
Thank you very much, and forgive my naivete. And then we're talking about up to, is that correct? Up to 5 1-year extensions after that.
Yes.
To build a home.
Well, Commissioner, you and I will always be on the same side on low income and affordable for people that don't have a lot of resources. But I don't think there's a affordable housing crisis above a certain level in Lane County. And so I'm assuming this relates to that. Well, I then, and I know I'm going to get chastised for this, fail to see why a 2 or 3 year extension equaling 6 or 7 years doesn't provide the certainty that I would need to build a house. That's just my feeling. I mean, what you said makes eminent sense. And it does provide certainty in a sense. I'm done. I'm thinking out loud. I apologize, wasting everyone's time.
Okay, so the motion, as I understand it, is to, with regard to this point, is to continue with the 4-year and 2-year extension and 5 1-year extensions. Up to 5 1-year extensions as part of the motion that is pending before the board. Okay, any further comments regarding this motion? Well, I think it's ridiculous to have 5 1-year extensions, so I'll be voting no. Okay, see no further requests for speaking.
Could I make an amendment or?
Yeah, you can always make a motion.
I would we simply amend this to not up to, but to, well, up to 3 years. I just don't see why this is a big deal. So up to 3 1-year extensions. I see no, I'm done.
Okay.
And I hope other commissioners will tell me why I'm incorrect in seeing no problem with that.
First, we're going to see if there's a second to your motion.
Second.
Okay, so you want to add more to that, or, okay, go ahead.
So this is why it's important. There are people that have already exhausted their extensions. Mom and pops, we heard testimony from them in previous public hearings. People that aren't developers that have been sitting on that land for a long time because they inherited it down through a family, went through the approval process, and it's not an easy process because we have a certain nonprofit in this county that appeals every template dwelling, every forest dwelling, every resource land dwelling approval we do, all the way through the process as far as they can. So you're talking about a process that can take years to go through the approval, thousands and thousands of dollars in permit fees and appeal fees, not to mention what they may have spent in attorneys and land use consultants that these folks have been kind of sitting on because it's their dream. And generally these folks, not all of them are rich. And by the way, the fact that there's purely a housing shortage on all ends, people buy down and causes a housing shortage in the middle and lower incomes. If they can't find an upper income home, they buy something lower and they build up the prices. So I don't care, housing is housing to me. I don't care where it comes in on the scale. You know, it brings down the price of all housing, no matter whether it's the $2.5 million thing up on the hill above Coburg, or it's a $200,000, half of a duplex in Bethel. It brings down the cost of housing if we have new housing. So what we're talking about here, and specifically why this bill actually got passed, was for those people that are living on the current one-year extensions. And there's a significant number out there. And these are folks that have invested an incredible amount of time and effort to hold on to that permit approval. And what we're saying, and what this bill did was, because there was a decision by LUBA that basically killed those extensions, which means suddenly these people that may not have the resources right at this time to build have to come up with the resources and try and get built within whatever's left of their current extension. If we don't approve these extensions, and 5 years may not be a lot of time for some of these people, even so, 5 years is a deadline now for those folks that are living on the extensions. So limiting it to 3 is basically saying, okay, mom and pop that have invested all this time, either you're going to lose your approval, and under new laws, you may not even be able to get an approval on that property, or you may not have the resources to go back through the process or the time. So, for me, 5 years was actually pretty limiting to some of those folks, because it's not really about the folks that are starting new and how long it takes there. It's about all these people that are now currently on one-year extensions.
Go ahead.
Commissioner, could I ask you?
Oh,
I'm sorry.
Let's have Commissioner Fargo next.
I didn't know. I'm sorry.
The chair did. I'm going to vote against this for a couple of reasons. One is that there's a natural process that people want to build as quickly as they can, so they won't. If there's a reason that they take the extensions as a particular reason, every time you push out the building of a property by a year or more, it escalates the cost of the property, of the materials, of the builders, of the development of roads. Anything that goes into building a property is going to be more expensive the further out you do it. So there's a natural selection process that causes people to build as quickly as they can. The second thing I'll say is that whatever level you build a house, somebody moves into that house that lived in a different house. And so if somebody is buying an expensive house, they probably lived in a less expensive house that they'll move out of. Then somebody will buy that house, and so on. It doesn't take any great extrapolation to understand that a house at the top creates openings all down the housing spectrum. So we are into building houses. We say that. We need to build houses. We're talking about a $50 million bond for middle housing. Well, probably somebody in middle housing is going to be occupying the higher level housing that's being built. So this is also building middle housing. But most importantly, people don't want to delay just for the sake of delaying, because delay costs money. They're not going to delay it to 4 + 2 + 5 times 1 more year, because it's going to cost a lot more to build it. Take a look at how much it would have cost to build a particular house 9 years ago compared to what it's going to cost today. People aren't going to wait just for the sake of waiting. They're not going to wait just to twist the lion's tail of Lane County and say, ha, got you with this one. That's not happening. People are delaying for reasons, and they will not delay because of the cost of the delaying the process. So really, whether they have 3 or 5 one-year extensions, they'll use what they need to build that house that we do need to be built in Lane County.
Go ahead.
Don't get mad at me, Pat. I didn't know you had your hand up. Okay. I'd like to make 2 points and then a question. And actually, the question is open-ended, but I would ask it of Jay. My 2 points are, I don't disagree with anything that was just said, but I think there are assumptions about that. One is, that is the case if there was no net in-migration, but there is. And I don't remember what the other one was. So I'm 1 for 2. But my question is, couldn't this amendment for the future provide a level of certainty, and couldn't we exempt those people in the condition you mentioned, Commissioner, that because so it's not artificially condensing their option to build?
So
forgive my naivete.
Yeah, I guess, and I'll maybe look at legal counsel a little bit, but the statute doesn't really say it only applies to those that are currently on one-year extensions. So our applicability of that statute, whether we could say those, basically the LUBA decision said we can't continue giving them one-year extensions. The House bill came about and gave us the option of allowing the one-year extensions for up to 5 years, to continue allowing those. It didn't say, and I don't know if there's some way we could say, those folks that currently are living on one-year extensions can get up to 5 one-year extensions. Anyone else doesn't get any, or something like that. I think what we'd find out is we'd end up in a equal application of the law lawsuit, but I'm not real sure, because I don't know in land use whether you can actually kind of make that sort of clear, that exception to, to under that statute. But that's, the best I can. And as far as in-migration goes, if those folks are in-migrating and there's not that upper-level housing, like I said, they buy down and they raise the price of middle-level housing, which then those folks that wanted middle-level housing buy down in the lower income and raise that price. You just kick people down the curb. Any housing keeps the price of housing down. I don't care where it is on the housing scale. It's just supply and demand, straightforward, economics.
We'll have that discussion
Yeah,
later.
yeah. But do you want to answer the question about being able to have
Is it
this only
possible?
apply to the people that are currently on one-year extensions?
Well, I guess it's significant to realize that folks who are currently on one-year extensions, they've gone beyond their 4 and their 2 years, there's a good argument that those development permits have expired, are no longer good, unless you apply this sort of retroactivity concept with respect to these additional amendments, with additional extensions. Whether you could tailor this code section to apply differently depending on whether you're within your 2-year extension or you've gone beyond that, maybe. I mean, I think I can't think of now who would want to challenge that other than perhaps moms or pops or developers or whoever who want another 1-year extension because it's toward the end of their 2-year. They're not quite ready to build because there's been a downturn in the market or increase in cost of lumber or whatever it is. And then they may challenge why am I treated differently than the person who already has the extension? So it does have some trickiness to it. So I can't tell you with any certainty we would be able to tailor something that would work in all cases. We could give it a shot.
Okay. So is there any further debate on the amended motion? On the amendment. Is there any further debate? Okay, so we'll take a vote on the amendment. That's the amendment made by Commissioner Bernie, seconded by Commissioner Buck. All those in favor of the amendment, please signify by saying aye. Aye. Opposed, say no.
No.
The amendment is adopted by a vote of 3-2. Commissioners Posevich and Farr voting no. We will now take a vote on the main motion as amended. All those in favor of the main motion, setting the reading on October 1.
Can I ask a quick question?
Yep.
So we are now changing language. Is the amendment clear enough that it passes the test of being a reading?
No, we
we
would
just-
want to read in,
Because how many times is 5 years mentioned, or what section is that three-year change got to be made in? I mean, I gave very specific section and reference to the amendment I made in my original motion.
yeah, no, at this point, if it's approved for another reading, I don't think that's going to be the last reading. We'll need another one after that unless you read in verbatim the language that's being changed and what's.
Which was not done.
Yeah. So
Okay.
going on to a sixth reading.
So all those in favor of the motion as amended, please say aye. Aye. Opposed, say no.
No.
Motion carries 3-2. Commissioners Farr and Bozovich voting no. We'll be coming back on October 1. Anything further on today's proceedings? Okay, thank you very much. Okay, at 3 o'clock, we're going to have our executive session. So let's do what we can for commissioners' announcements at this time, item 14A. Do any commissioners have any announcements? I will say that I was informed by Dr. Casey Creer that his last day as Lane County's performance auditor will be September 17. I just wanted to add my congratulations for his service as Lane County performance auditor and wish him well in his new career. Are there any other commissioner announcements? Commissioner Buck.
I'll just mention, since our last meeting, I was able to attend 4J Back to School Gathering on the 29th, which was well attended, and I thought that went really well. We heard from both the Teacher of the Year, which is from Churchill in my district, and we also heard from Kid Governor of the Year, who is from McCormick, who's also in my district. And I think they did just a wonderful job speaking and inspiring the teachers for the next school year. My little one just started kindergarten last week, so it was pretty exciting for me, too. After the first day of school, I meandered up to Oak Ridge and was able to attend their open house for their renovations from their bond that they passed. And this is they're doing half their upgrades this summer and then next summer. And we got to go on some tours, and it was looking really good. And I think people were really pleased with the outcome of their bond up there so far.
Okay, thank you. So item 14B, agenda team requests. Oh, you had an announcement, okay. What is your announcement?
I want to thank the board for allowing me to go to the Wayfarer grand opening this morning. We actually heard from Wayfarer founder Steve Cronine, very interesting guy. He dresses a lot like another Steve that we know very well. I won't go into detail, but Wayfarer has already hired over 200 people. I learned their projection is to hire 600 people total. Wayfarer is located in the old Symantec facility in Springfield. Mayor Lundgren was there with many Springfield City Council members and leaders of the Springfield community. Wayfarer has an interesting corporate policy. They've already given to 12 local charities, including United Way, and a bunch of others that I can't remember all the names. They also have an interesting corporate policy because they underwrite the costs of volunteerism with their employees. I don't know how much, but I know it's significant, and we're going to be conversing about expanding that, actually. So I had that opportunity. So thank you, Board of Commissioners, for allowing me to do that and allowing me to welcome a new employer into our community.
Thank you. Other commissioner announcements? Seeing none, we can move on to item 14B, agenda team requests. Commissioner Buck.
Playing off my announcement earlier, I had a chance to chat with our Oregon Kid Governor. And lo and behold, our state kid governors have a handler from the Secretary of State that does all their scheduling for them. And I had mom, I had kid, and I had the Secretary of State person all kind of there, and asked if they had any interest in having our kid governor come sit with us on the board for a meeting or part of a meeting. I'm sure it'd be pretty boring for a young kid to be here all day. But they had a lot of interest in that, but before I made the official ask, I just wanted to see if there was interest from our board to invite our Oregon Kid Governor
to visit us for a day. We could have them tour the county, get familiar with what we do here, and maybe sit in with us for a little while on board.
I think that would be a great idea.
Thank you. It's no guarantee that it'll be able to do the scheduling right, but I'm hoping that we could do that.
Okay, and this is apropos of our discussion of other agenda team requests. Are there three commissioners that want to further the invitation of the Oregon Kid Governor to come to Lane County and watch us for a while and meet us and go around to the county government? I see two of the 5 commissioners that want to do that.
I'm
see-
fine.
You are fine. Okay,
I just don't want them to know that I'm not particularly intelligent.
Okay, well, yeah, I can remember when we had the real governor come. So we've had real senators and real governors come and real congressmen, but I like the idea of having the kids come too.
I think it's important to somehow extend our welcome to the youth because we don't get to see them very much here on our board. And this is a good
I'm more in favor of it because they're a Lane County resident.
that too.
Thanks. You know, in the past, we've had classes visit fairly often from Willamette High School, from Calapooya High School, from Triangle Lake High School. And, you know, it's something that we do. We've never done anything for an individual such as this, and I think it's something we could explore. I'm not sure how we say, yes, you can, and no, you can't.
Right.
So if we have 50 people say, can we do this? At which point do we say, can't really do this anymore? So it may be something that we would want to talk about as a board at some point. Do we want to extend individual invitations as opposed to a blanket invitation that we have for any class that wants to come and sit and visit our board meetings?
Okay. Okay, one of the items brought up in the public comment was to get some information on the various EPS, also known as food container styrofoam bans. I thought that was worthwhile. I would probably want to narrow it to food containers, and I'd like to, at this point, just request that we get a report back on how difficult this would be to implement and how it will be implemented and get our, so I would draw a distinction between this as an agenda team request as opposed to a work session request. So I would like to pose an agenda team request, so we get information from staff and that they present that information in response to this request. But we'll only move forward with that if there are 3 commissioners. Commissioner Farr?
Thank you. You know, I'm starting to become a little concerned with all the requests of staff, even if it is just a report back. It does involve staff time in preparing that. And last time I checked, staff has pretty full agendas already. I'm not saying that's a bad thing to do, but if we continue with these requests, I guess at some point we need to kind of have a quota of what we can ask staff to do. At some point, we're going to get to the point where they simply cannot do any more of our requests. So I'm concerned that each time 4 or 5 or 6 or 10 people come and make a presentation to us, that we have a work session or report back based on a request from a number of people who may make a request during public testimony.
Okay, yep.
I share Commissioner Farr's concern, actually, ironically. I totally agree with the issue of styrofoam and other things. And I didn't agree with the comment that we don't have to wait for, some Sermon on the Mount on climate change in order to deal with this. But I agree. On the one hand, I'm very interested, and I will personally Google, and I will find out before staff reports to me what different counties have done with styrofoam. But and I expect to discuss this tomorrow. I'm starting to see a disconnect between my interests for the county looking at issues and piling up indiscriminately work sessions and work requests as I'm looking at these agendas. So I share that concern, even though obviously this is an issue.
Well, again, the purpose of this provision on the agenda is precisely to measure whether or not the board wants to put energy into a topic or not. And I'm saying, hey, this looks like a pretty low-hanging fruit thing that other communities, including the city of Florence, have passed these styrofoam bans for food containers, and it hasn't created too much of a problem. The U of O, we heard this from testimony today, U of O banned styrofoam food containers. Why can't Lane County ban styrofoam food containers? I'm not saying we should have a big work session on it. I'm saying we should get a report back from staff, and if it's simple enough to pass an ordinance on it, let's keep moving on it. If it's not, if the report says, no, bad idea, don't do it, it's just too much work for us, then you'll have your answer that we have piled too much on. But part of what they said was they'd talked to the people in Public Works and said they were taking the direction from us and they were in favor of it. That's kind of what I got. Yes, sir.
So first, let me echo the concerns of both Commissioner Farr and Commissioner Burney. I think we are being steered too much by public testimony in making requests to staff. I've echoed that several times today, whether it was our emergency declaration on homelessness, and then for some reason we turn around and limit housing permitting, but still in the same day. Emergency declaration on homelessness, to having to release legal documents to outside attorneys to supposedly give us advice that won't have any application at all to us in the future because they're not our legal counsel and their advice won't stand up in court for us. We have to have some discipline, and I'm hoping tomorrow we develop some of that. But let me just say on this particular issue, I have no interest in looking into it. I believe this is a matter of education and getting the public to express their desires to the food vendors, et cetera, about what they want in their containers and let the market fix that problem. Just as, you know, it's pretty easy to find organic groceries right now, you know, and non-GMO stuff because the market's demanding it. You know, if the folks want to start, you know, when they call in for carry-out food, go, oh, by the way, do you use styrofoam containers or do you have an alternative? You know, and if people ask that question every time, the market will respond. Why do we have to use the heavy hand of government to dictate people's behavior and the economy? I have no idea why, and I'm not interested in looking any further into this item.
Okay, so Commissioner Buck.
So I'm not a big fan of styrofoam, but as I chat about this in response earlier, I did actually have some email traffic with Dan Hurley on this particular issue. And he has some specific comments that I wouldn't mind, you know, have him giving us an update with his thoughts on it. But unless this is part of a larger product stewardship conversation, I think I also need to back away from this as a specific item that we need to make a request on, because there's more involved in this particular issue than it seems on the surface. And I would want to have Mr. Hurley's input in that. And that could be an update when he comes back on a climate change update, or whenever he's back here when we're in a session.
For the record, I was emailed also. I like the term email traffic. And I also forward any emails that relate to the subject of climate action plan, because it seems to have interested some groups in the community, to Mr. Hurley. And Mr. Hurley has always been getting back to them. And this falls into that category. And so I would agree with Commissioner Buck on this. Not that it's not an issue, but there are consequences and then there are ramifications and there is a context. And I think, and congratulate this board, is that we're actually going to look at that bigger picture.
So I heard Commissioner Buck say she would like to hear back from Dan Hurley on this in the context of whatever else is going on. So do I hear two commissioners want to pursue it? Do I hear three? think Mr. Mokryski, I think he would like to know what the preference of the board is.
One option, Mr. Chair, that I just offer is that, we can check on when the next update. You just got an update on the climate action plan from Dan Hurley a few weeks ago. But we're, planning, I think, regular updates on that. And so we can ask that he provide some information at that next regular update of the climate action plan.
I would support that.
So I would say that, as far as this agenda team request, is that it's dead because there's not enough commissioners that asked for it. Mr. Hurley will be making reports as normal. Okay. Are there any other agenda team requests? Okay.
Mr. Chair, can I just get clarification on under my announcements, I talked about the CCA request. We had an open assignment to draft a letter, and I guess I'd like some clarification based on the information I shared with you, which direction the board would like to go on that. The opt-out, the discussion about a letter to the Department of Corrections on the opt-out.
I guess we'd like to have a letter, but I guess your comments are tempering what the letter might say, and we're awaiting the letter. Yeah.
As the original requester of that item, things evolve, as the administrator stated, and I think it's in our best interest to withdraw sending the letter in and follow some other tactics. I mean, changes since I originally asked for that agreement, is that a local state senator has become the co-chair of the subcommittee for Ways and Means on Public Safety. So to have his county that he represents, because his district is wholly within Lane County, send a letter to the governor about this might not be the best thing for him in leadership. And as we're working with him to champion getting additional funding for the Community Corrections Act, things have changed and the strategies changed. At the moment I made that request, that was probably the best strategy, but it's no longer the best strategy as politics and things change. A little bit different than a piece of land or something that doesn't really change. This is people, and politics is a social science. Things change and conditions change, and I think we need to be flexible and change with it. So I would ask the board, just let this one die, and we just move ahead with Alex Kyler's guidance and some of the folks on the PSCC that are helping work with Senator Manning and some of the leadership up at the state to try and gain back at least 25 of the 50 million that we were hoping to get.
I agree with that. Okay, so I would say consider that the amendment to the assignment. Okay, so let's move on then to executive session. At this time, the Lane County Board of Commissioners will meet in executive session to consult with counsel regarding the rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to RS 192.6602H, which allows the Board of Commissioners to meet in executive session for the purposes listed. Representatives of news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session except to state the general subject of the session as previously announced. No decision will be made in executive session. We reserve the right to come back out of public session, out of executive session into public session should the need arise, and it will need arise because we need to finish the rest of our agenda. We'll be in recess for 5 minutes while we go up to the Board of Commissioners conference room. Thank you. resumption of the public part of the Lane County Board of Commissioners meeting for Tuesday, September 10, 2019. By my count, we've done everything on the agenda except for review of assignments. And Mr. Mokrajewski, at this time, I'd like to call on you for a review of assignments.
So I don't have any new assignments, although there were two things discussed. One, Commissioner Buck's request to invite the KID governor to sit in on a board meeting, and I think we won't add that as an assignment. We'll just, what I heard is Commissioner Buck is gonna make that invitation, and the commissioner supported that.
I'll reach out.
Okay. And then the other was to remove the existing assignment to send the letter to the Department of Corrections regarding the potential option of opting out of parole probation, so we're removing that. Those were the only two, other than the fifth reading that will come back on the afternoon item,
Of October 1.
October 1, right? But that's not an assignment. It's just a follow-up.
Okay.
I'm sorry, and then, I will say then, we'll send an email to Dan Hurley just to remind him that the next update he gives on the climate action plan to provide some information about
Material.
EPS and food containers.
Or was it general material banning?
Well, that's, I think it's personally, I think it's a bigger category of materials banning,
Okay.
but.
Materials management, so maybe we'll have him touch on materials management and,
Well, it was particularly banning certain materials. That was part of this discussion. I mean, in this instance, what was brought up was very specific, but I think he'll want to say something on a larger scale about the
broadly, okay.
issue.
okay.
Okay, anything to be brought to the administrator's attention on review of assignments? Okay, so my present plan is to recess the Board of Commissioners until 9 AM tomorrow morning. Hearing anything further? Okay, so we are in recess till 9 AM tomorrow morning in Springfield. Thank you so much.